Final presentation project, Business 343, Employee and Labor Relations, Jackie Fucartas. Grievance discussion case number 1, is an adoptive mother entitled to maternity leave? Question number 2 is answered as legal counsel. As the attorney for AFSCME Local 10, develop an argument to support your client's contention that the council's rejection of Carol Fern's unpaid maternity leave request violated the collective bargaining agreement. Next slide, please. Description of the case. Carol Fern has been an employee of Bainbridge Borough for 18 years as a tax clerk. Her position is represented by the Local 10 of the American Federation of State Courts and Municipal Employees, the AFSCME. Carol and her husband were unable to conceive their own child and chose to adopt. On April 22nd, they were notified that a baby girl would be available for adoption in 3 days. As it was April and it was during tax season, Miss Fern did not think that it was fair to leave Bainbridge Borough on such short notice and asked for a delay of the adoption until May 2nd. On April 27th, Fern requested a 2-week paid vacation from May 2nd until May 17th. And her request was granted. Fern asked for a 6-month maternity leave on May 16th, which was the day that before she was to return to work. Bainbridge Council rejected her request in a 4-3 vote. They did offer Carol 2 successive 90-day reasonable purpose leaves. And on June 1st, a grievance was filed citing Article 10, Section 4A, Unpaid Leaves, 5, page 13 for maternity leaves. Next slide. My position. As the attorney representing the AFSCME Local 10 for Carol Fern, my belief is that the rejection of Carol Fern's request of a 6-month maternity leave by the Bainbridge Borough violated the collective bargaining agreement that protects the rights of the employees at this company. Carol is the mother of a 3-month-old child in whom she adopted according to the collective bargaining agreement. Her request for a 6-month maternity leave should be granted. Her maternity leave should be granted based off of Section 5, maternity, on page 13 of the final agreement between Bainbridge Borough and the local Union 10. Maternity leaves not exceed 6 months shall be granted at the request of an employee. Maternity leaves shall, upon the request of the employee, be extended or renewed for a period not to exceed 6 months. In the bargaining agreement, it does not stipulate whether the child is biological or adopted. And since Carol did not exceed the 6-month limit, she is not in violation of her part of the collective bargaining agreement. Next slide, please. Research. The Family Medical Leave Act, the FMLA, protects the rights of a parent, maternity or paternity, leaving a newborn or adopted child for up to 12 weeks. The employee must have completed 1,250 hours in the past 12 months of work. It is also recommended that adoptive parents should take time off to allow a relationship to build. And the rule of thumb is for the year that your child was not in your home, you should cocoon for 1 month, if at all possible. Take leave from work in order to facilitate the bonding. An adoptive mother was granted maternity leave in 1983 after a grievance was filed against the AFSCME because they denied her request for 1 year unpaid maternity leave. The union's defense is that maternity leave is a contractual right and cannot be denied. The company did not want to set a precedent as they felt the benefits were meant for women who conceived and delivered their own child. Next slide. The American Federation of State, County, and Municipal Employees is in over 46 states and represents over 1.4 million workers on issues that affect workers, including health care and benefits. Maternity leaves are covered in the bargaining agreement, Section 5, Article 10, leaves of the absence, Section 4A, unpaid leaves. It shows that leaves are not to exceed 6 months, shall be granted at the request of the employee. Maternity leave shall, upon the request of the employee, be extended or renewed for a period not to exceed 6 months. Bainbridge Borough entered into a collective bargaining agreement where the terms and conditions of employment, including benefits such as maternity leave, are legally binding between the parties. Next slide, please. Argument to support case, page 2. Reasonable purpose leave is only for 90 days, and Bainbridge Borough was willing to give 2 consecutive 90-day leaves as maternity is guaranteed in her contract. If Carol accepted the terms of the reasonable purpose leave and did not file a grievance requesting the maternity leave, then she would be setting a precedent for the future cases going forward. Next slide. Plan of action. As her attorney, I would petition the council with an appeal for them to re-vote based off of the collective bargaining agreement between Bainbridge Borough and AFSCME. If an appeal is not granted, then I would ask for arbitration. In the appeal of reasonable purposes does not support the adoption of a baby as it is considered maternity leave that she is requesting. Once the maternity leave is directed, Carol Fern should be acknowledged retroactively to her last day that she worked, which was May 2nd. Next slide. Conclusion. Carol Fern is deserving of the 6 months of unpaid maternity leave. The ruling by Bainbridge Borough Council should be overturned to support the collective and bargaining agreement. And since Carol's request of the maternity leave that she is asking for the allowable time off, it should be granted.